My practice in federal labor and employment. You can see my bio on the screen and my contact information. As Taylor mentioned, we will be taking questions at the end of the presentation, but I will not be able to answer specific questions regarding any case you have. It will be more general questions that I can answer. So if you do have any questions that are specific or you want to talk up to me about your case, you can jot down my contact information and reach out and we can set you up with a consultation to talk about that. Next slide, Taylor. What we will cover today is what to expect during your initial status conference, preparing and submitting your discovery requests, responding to the agency's discovery requests, any motions that might occur during the discovery period, and preparing for depositions. Just to be clear, this stage of the case comes after you have filed a hearing request to the EEOC and have been appointed an EEOC judge. This comes at the end when you receive the report of investigation at the end of the formal complaint stage. So at the end of the formal complaint stage, you will receive your report of investigation and a letter advising you of your rights. One of your rights is that you can request a hearing before an EEOC judge within 30 days. If you do that, this starts the process that we're going to discuss. I just want to make sure that everyone's clear where in the process we are for what we are discussing. And next slide, Taylor. So that is how we got here. And it reiterates exactly that process that you have to go through the informal complaint stage. You have to go through the formal complaint stage. You have to receive the report of investigation and file a hearing request. And it must be done within those 30 days that after you receive your report of investigation. So next slide, Taylor. So typically after you file your hearing request, depending on what field office or district office you are filing in, you will receive an acknowledgement order. And this acknowledgement order is kind of a standard form order. It is not specific to your case, most likely. And it may or may not have a judge assigned to your case yet. It is advising you of the process for hearing and typically what will be discussed and some guidance to go over. Most likely you don't have to do anything after receiving the acknowledgement order other than read it. The order will designate your EEOC file number for your matter. That is the number that you want to use anytime that you email a judge, you email the agency, you talk about your case, you want to use that number. Up to this point, you've been using your agency case number, which varies based on what agency you're at. You can use both. In most pleadings before the EEOC, you identify both the EEOC number and the agency case number. Like it says, typically this acknowledgement order comes about 3 to 4 weeks after you file your hearing request, but this varies based on what office you're in. So there is no set deadline for the acknowledgement order to come out. Sometimes you also receive just an email telling you that your case has been assigned to a judge and that it's active on the portal, and you need to upload any sort of motions you may have filed, objection letters that you filed during the formal complaint stage. So sometimes it comes in that form and sometimes it comes in the form of the acknowledgement letter. All right, next slide. So I want to caveat this. For a long time, for a number of years, the EEOC offices were requiring a preliminary case information sheet. The EEOC has since moved away from this. Most of the acknowledgement orders coming out right now are saying we are not doing a preliminary case information sheet. So it'd be very unlikely if you're at this stage right now that you would receive this preliminary case information sheet. However, it is a basic form to advise the judge what you're planning to talk about during the initial status conference. But like I said, if you were to file your hearing request tomorrow, most likely you're not going to get this. Most judges in the acknowledgement order or in the order scheduling the initial conference say, I am not requiring a PCI. But this information is here in case they do. Every case processing is dependent judge by judge. So what one judge wants versus another may differ wildly, and you really don't know what your judge wants except for reading their orders, which is why that is very important to read the orders, the acknowledgement order, any email orders you get from the judge, and understanding what needs to be done. All right, next slide. So after you receive acknowledgement order, most likely you will receive an order scheduling an initial status conference. And in that order, the judge will, this is where some variation may occur. Most likely the acknowledgement orders are all going to look the same, but the order scheduling the initial conference may be different. In that order, the judge will tell you, one, when the initial status conference is, and two, the issues that that judge wants to discuss during the initial conference. Most likely, it's a standard list of what they want to discuss. They want to discuss the claims at issue and make sure everyone's on the same page as what the claims are. They tend to look at the letter of acceptance in the report of investigation that the agency issued. Now, if you disagreed with how the agency captured the claims in that acceptance letter, or you said that they improperly dismissed a claim or claims, then you would want to tell the judge, hey, look, I objected to how they framed this. I think it's wrong. Or they dismissed these claims without any basis. It really was timely because, for example, it's a hostile work environment, or it was related. I did timely amend. You want to have those arguments ready to go because that will be the first thing you likely talk about at an initial conference. The other thing that you will talk about that is of importance at the initial conference is you're going to talk about settlement. Most likely, the initial conference order will require you to talk settlement with the agency. Typically, how that process goes is the complainant conveys a settlement offer and the agency responds to it. The standard process is that the complainant goes first. That has absolutely nothing to do with strategy or weakness. You know, the weaker party gives the offer first. No, that's not how it typically goes. Complainant goes first and the agency responds. I like to put together a comprehensive settlement offer that you'd be willing to accept, and kind of break it down item by item so the agency understands it to give them the best opportunity to respond. But the agency's response can be anything from thanks, no thanks, we reject the offer, we don't want to move forward with discussing settlement any further, or they can offer you something that is meaningless to you, like $2 and a bus ticket, or they come back with an offer, even if it's not an offer that you would accept, it shows you that there might be some negotiation. So those are the three basic types of responses from the agency. Sometimes they don't respond at all. And so the judge is going to ask at an initial conference, parties, did you engage in settlement discussions? And I start off saying, yes, Your Honor, I conveyed an offer on this date to the agency. I never say what wasn't specific in the offer. The judge is the trier of fact here. And at that stage in the case, I don't believe it's appropriate for the judge to be involved in settlement discussions absent an agreement with the parties, because they are going to be the trier of fact. And that opens up the opportunity for a bias to be formed really against the complainant or the agency. It's just an opportunity for the judge to think one of the parties or both of the parties are unreasonable. And I don't like to create that situation. So I say, Your Honor, complainant conveyed an offer on this date to the agency. And then I say what the agency's response is. So I'll say the agency has yet to respond, or the agency respond rejecting complainant's offer and not providing a counter offer, or the agency responded and conveyed a counter offer. At this time, the parties are too far apart that we don't think settlement is likely. Or in a very good case, we say, Your Honor, it seems that while there is work to be done between the parties, we feel that settlement discussions may go somewhere and it may lend to resolution. At that point, the judge is going to transition the conversation to, do we want to pursue settlement? Do we want to do a settlement conference? Do we want to bring in a mediator? Does the judge want to do a settlement conference? So these are things that the judge is going to want to walk through, and you must do this before the initial conference because the judges, almost all of, I'm going to say all of them, like to know whether a case can be resolved before you spend the expense of discovery. So it's a very important conversation to have. The next thing that the judge is going to talk about is discovery. Exactly that, setting the schedule. The judge may ask the complainant, what do you want to get out of discovery? What is it that you're looking to seek? What type of discovery? How many requests do you want? What kind of, what's the time frame you're thinking is reasonable? And you need to have an understanding of what is missing from the ROI that you think the agency may possess that you think may lead to relevant information that you would want to present at a hearing. So if you notice that there are no emails in the ROI, and emails probably happened talking about whatever the facts are in the case, you may want to ask for emails between the responsible management officials. If you know that you submitted medical documentation and you don't see that in there, or you don't see that it was ever sent to the reasonable accommodation coordinator, these are things that you would be looking for. So the judge is going to set the deadlines for discovery and then dispositive motions, commonly referred to as a summary judgment motion. And these deadlines are extremely important. You need to make sure you calendar them and you're well aware of them. You are able to request an extension, but until that extension is granted, these are the deadlines, and failure to meet the deadlines could result in your case being dismissed. And you don't want to ever present that opportunity. All right, next slide. I should say about the initial conference, I just want to add, in most circumstances, it isn't a hearing like you're going to have to prove your claims. The judge may ask for some explanation on some claims, but most circumstances, the judge is not going to ask you. It's not a hearing. It's more administrative, how we are going to process the case. That's the purpose of the initial conference. So you are not expected to present evidence or witnesses. This isn't the hearing. So I just want to make that distinction because that is a very confusing point. Now some judges do it a little differently, and you just don't know based on what judge you get, but that should be in the judge's order when you get it. So again, always read your judge's orders. Preparing for discovery. Discovery is a very important stage in a case. It is very time consuming, it is very laborious. You have a lot of work you have to do. And this is because it is, one, the opportunity for you to get everything the agency might use in their case or in defense of your case at hearing, everything they may use against you, every witness that they may have to come and talk against you. This is the opportunity to discover all of that information. It is also your opportunity to make sure that any evidence you have, if the agency asks for it, you need to provide it, because otherwise you will not be able to present it at a hearing. I'm going to repeat that because it's very important. If the agency asks for evidence that you have and you do not provide it during discovery, you may not be allowed to use it during the hearing. That's incredibly important. You're thinking about, what do you need to prove your case? What is it that I need? Do I need a specific email that I think exists where they talk about my protected class? Do I think that there are notes somewhere where they talk about, discriminating against me or retaliating against me? What is it that exists? Is your case a non-selection case? And so you want to be looking for the interview notes, the person who was selected's resume, because you have to show that you are the most qualified person for the position, and you need to do a comparison. Things like that. Typically, discovery is 90 days long. I am noticing, however, that there is a tendency for judges to try to make that shorter. They're going away from a 90-day discovery period only and reserving it only for cases that are extremely complex or have a lot of claims, and they're preferring a 60-day discovery period. I'm still requesting a 90 days because scheduling depositions can take a while depending on the time of the year, but 60 to 90 days tends to be the typical. You must be specific in your discovery requests. You must be specific in your discovery request. You have to tell the agency what you're looking for, just like the agency has to tell you what they are looking for. And there may be a tendency to kind of hide the ball, but don't hide the ball. You want what you want. You need what you need. Ask for it. Because if they don't provide it and then they try to use it at a hearing, you can say, hey, judge, look at my discovery request. It's very clear that I was asking for this information here. And it's very clear from their response, they did not provide it. They cannot use this now at hearing. This is prejudicial to me. So you need to be very specific. You need to state people's names, full names, if you know them, their positions, and you need to be as specific about dates as possible. Remember, you can refer back to the ROI. So if the RMO refers to something in their affidavit, like, yeah, that email I sent on July 15th, but the email that he sent on July 15th is not in the ROI, you can refer back to that and say, I want the email that's referenced on ROI page 87. And the more specific that you are there, the easier it'll be for the agency to provide it. They'll have a reference point to go back. So you'll have the ROI, and whatever's in the ROI is already evidence. You don't have to do anything to get that entered as evidence. But you're looking at information that can supplement what's already in the ROI. So this could be witness statements, missing documents, supervisor quotes that you want to put into your request and have them explain, anything like that. The goal is to try to make, to try to uncover information that the agency isn't revealing or hasn't revealed yet. Again, so most likely at the initial conference, the judge is going to set an overall discovery deadline. You have to complete it within 60 to 90 days. Most judges set an initiation date, which is why you have to read the orders very carefully. So in order for you to be able to get discovery, you have to initiate, which means send out your request to the agency by a certain date. Some judges don't put any dates in there. They just have a close of discovery. That's fine. You just have to give reasonable time for the agency to respond. That's the last possible date. What the definition of reasonable time is up for interpretation, but I would say a rule of thumb is about 20 to 30 days. But make sure you're complying with dates. If you do not initiate discovery by a date certain in the judge's order, you waive your right to discovery. It's also important to note that if the agency doesn't initiate discovery by a date certain, as listed in the judge's order, they have waived their right to discovery. Now, as I've said before, after discovery period ends, no other evidence can be admitted absent exigent circumstances. If new evidence comes to light and it was not known of, no one was aware of it at the time, that is an exception. But otherwise, anything that you want to use during the hearing must come out during discovery. All right, next slide, Taylor. Discovery responses. So just after you send your request to the agency for discovery, most likely they're going to send you requests for discovery, and you need to respond to them. You need to respond fully to them. Again, this is not the time to play hide the ball. You need to provide honest and accurate responses. You can object to certain requests by the agency. So if the agency were to ask you, to describe all conversations that you've ever had with your attorney about the case, that's objectionable. That you don't need to respond to that. That is in violation of the attorney-client privilege. There are other objections that you can make. They could be the request is too vague. You can't figure out, if they ask you to produce every tax return you've ever filed, that's way too broad. That's not narrowly tailored enough to be relevant to the case. And so you can object to that and require them to narrow down specifically the time frame. And typically it's the time frame in the case. You can maybe go back a year or two on either direction, but it's going to be most likely narrowly tailored to the time frame in the claims. But you want to make sure that you are providing any information you might want to reference. So even if you have an objection, like for example, those tax records, if you're claiming damages and lost wages, you're going to have to show that you lost wages. And the calculation for lost wages isn't just, okay, I wasn't getting my paycheck, so it's the value of the paycheck. It is the value of the paycheck minus whatever income you had for that year, for that period. So you're likely going to have to turn over some sort of record to show what your income was and show what your actual damages were. So that might be something. And you want to provide because you want to prove your damages. It is important to indicate if information is already in the record. I do this as well in my request. Sometimes the information is already in the ROI, okay? And so you can just cite back and say, all the information I have is at ROI page 56. That's perfectly acceptable answer. It is also a perfectly acceptable answer to say, I have no documents responsive to this request. If they ask you to produce all arrest records that you've ever had, you've never been arrested, I have no documents responsive to this request, period. And we ask questions like that too, because we want to know if anything exists, right? We ask questions sometimes of, for the RMO, any other EEO complaints that they've been a part of, and any findings of discrimination against that included this RMO. It may very well be the case that there have never been an EEO complaint prior to yours against this particular RMO. And so the correct full answer would be, we have no documents responsive to this request. Remember, it's important to note that you are not filing your discovery requests or your discovery responses with the judge. The judge will go over this with your initial conference, but you don't send them to them. The only time the judge gets involved in discovery is there is a dispute. You say the agency should produce something, they're refusing to produce it, then you get the judge involved. But you do not provide discovery requests and discovery responses to the judge, period. Remember, when your discovery responses are due back, likely the judge's order, this is in EEOC cases, it's usually 30 days, but double check. Double check you have that deadline. The ultimate deadline is that discovery closing date. You must have everything back by then. Okay, next slide, Taylor. Possible motions during discovery. So like I referenced, if there comes a thing where you ask for a certain something and the agency's refusing to provide it, what you have to, the judge's order will set up a possibility for you to file what's called a motion to compel. But prior to filing a motion to compel, you must comply with the judge's orders regarding meeting and conferring. So you have to, in most circumstances, tell the agency, hey, I think this response is deficient, and this is why I think this response is deficient. You haven't provided this, you haven't answered this question, and you have to provide them the opportunity to supplement their request. So, oh, you're right, we didn't include that, here it is, blah, blah, blah. But you have to have this discussion. I like to send a letter or an email outlining the responses that I think are deficient. And let me explain what deficient means first. It isn't that you disagree with the answer, that the answer is incorrect. That is not a deficient response. That's just an answer you believe is incorrect. Deficient means they didn't provide the response, the answer. So they objected to it and didn't provide an answer, or they provided an incomplete answer. Doesn't mean that you think that the answer is right or wrong. That's not what deficiency is looking at. It's looking at whether the answer included all the required information. So if you say, any witnesses that might have witnessed this event, including their name, their status, or their position title, and their organizational relationship, and the sum and substance of what they witnessed, and they don't provide the sum and substance of what they witnessed, that's a deficient response, and you can ask them to supplement with that information. But you must have this opportunity to go back and forth. The agency similarly has to do this. Be very careful about looking at the judge's order. I sound like a record on repeat about when you have to meet and confer, and then what your deadline is for a motion to compel. In most orders, you must file a motion to compel within 10 days of the deficient response. 10 days. It is a very quick turnaround time. You have to review the responses, have that meet and confer opportunity, and then file within that 10 days. That's a very tight timeline. If the deadline happens to fall on a weekend, it's the next business day. But you must do that. Some judges require that if you want to file a motion to compel, you must first seek permission. And so they will detail process for you to seek permission to file the motion to compel. So you have to be it's very judge specific on how you go about this. Some judges want to be emailed and have a status conference before you file a motion to compel. Some judges just want you to file and then they'll deal with it. So got to pay attention to what your specific judge wants. But you have to be able to say what is deficient about the response and what the agency should do. And having that meet and confer letter or email helps you do that. You can say, look, I told the agency that they failed to provide the reasoning as it's requested. And I told them about that. They refused to supplement it. They should provide that. It was in the request. And it may be that the judge thinks that information could lead to relevant information, which is the standard in discovery. And they force the agency to provide that information. If the judge accepts your motion to compel and the agency still fails to comply with the order, you may file a request for sanctions. I usually tack on a request for sanctions at the end of all motions to compel, just in case. And you can be as broad as saying any sanction that the judge deems fit. But that is something that you can request. Now, just as you can do this to an agency, the agency can do this to you. So if your responses are incomplete, they can move to compel a more complete response. And so you need to be cognizant of that. If they come to you and say, hey, your responses are deficient for X, Y, and Z, can you either supplement or clarify? Sometimes it's being very specific about saying, I don't have that information. I am not in possession of that information. And you just need to be as expressly upfront about that as possible. And that clears up the deficiency. Other times, you got to answer the question. So unless there's an objection to the question that you want to stand on, got to answer the question. Okay. All right, let's move on to depositions. So there are two components of discovery. There's written discovery, which is what we've been talking about before. There are three types of written discovery. There are requests for interrogatories, which are just questions. Explain every which reason why the agency took the action they took. That's an interrogatory request. It's not a very specific one. I would add more specific things based on a case, but that's an interrogatory request. Then there's a request for production, which is a request for documents. So I want every email that the RMO sent regarding this event to the people in HR. And again, you're looking for things that are not in the ROI. And then there's something called a request for admission. These are single facts. One fact that you want the agency to admit to. Admit that I submitted my reasonable accommodation request on this date. And the point of this is either to get them to make an admission that helps you, or down the road, you're going to have to do stipulations of fact. These are facts that they should agree to. It's not disputed, and so we can just detail them out, and there they are stipulated. After written discovery, there's also depositions. Depositions is the opportunity for someone to be questioned under oath in front of a court reporter. This is outside of written discovery, and this is an opportunity for either you, your representative, to question critical witnesses or responsible management officials about almost anything. Depositions are a very wide opportunity. So the agency can question you about almost anything, and you can question a RMO, a very specific witness about almost anything. Now, you shouldn't abuse that, but there's very little limitations on depositions. A court reporter will be present during a deposition, and this will be testimony that is produced in a transcript and can be used as evidence in the case. So it is very important because this could be, a famous line, it can be used against you, it can be used against you, and it can be used against the agency witnesses as well. If you have a deposition, if you would like a deposition to take place, you have the responsibility of ordering a court reporter and paying for the court reporter. So you are not only paying for the court reporter's time to be there to transpose everything, but you also will pay for the transcription. Now, this is for any deposition you take. If the agency wants to take your deposition, they have to pay for the court reporter, and they have to pay for the first transcription fee. You pay for a copy if you want a copy of that transcript. But any deposition you're initiating is the one you have to pay for. So you need to figure out who is it that you want to depose and for what reasons you want to depose them. Depositions are expensive, as I've just explained. It takes a lot of time. You can have up to 7 hours of on-record testimony, which means actually time used, not time in a day, but how much time you were on the record and recording. That can be very long, and thus transcripts can be very long. So it is very expensive. For most people, you have to determine, okay, who is the most important person I would want to depose, and then kind of make cuts from there. You want to depose the person that you think will be the primary source of information at a hearing. General rule of thumb in a hearing is you don't ask a question that you don't know the answer to. And by that, I mean you don't know how the person you're asking the question to will respond. So you want to have all of that information in a deposition prior to getting to a hearing so you can know how that witness is going to respond to something and prepare for that. So if they're going to disagree with what you say happened, You want to know that up front so that you can prepare your questions for hearing and attack that response in a hearing. A deposition is not a time for necessarily an attack. It's a time to understand how they're going to respond to things and see if you can trip them up at all. Because you can use a deposition transcript to show that a statement is inconsistent at a hearing and impugn their credibility. So it's a very useful tool. But because of the expense, in most EEOC cases, people don't take 7 to 10 depositions. It's usually 1, 2, or 3. So you really want to think about who's your primary. You do not take a deposition of a friendly witness. If this is someone who's willing to testify on your behalf or willing to do an affidavit, don't take their deposition. That's not nice. It's only people against whom you think will testify against you. You want to ask questions that you think will be questions asked at a hearing. You also can do some background information. So you want to know how long they've been an employee. You want to know if they've had any other EEO complaints filed against them. Did they have any military service? Have they ever been arrested? Things like that. You can ask some background questions, but you really want to focus your questions on the claims at issue and what will be asked at hearing. In terms of prepping for your own deposition, biggest rule of thumb when you're being asked questions is answer the question asked. That's what you need to focus on. You don't need to focus on the reasoning that they're asking you the question, why they're asking you the question. Answer the question asked honestly. End of story. If you do that throughout your deposition, you're not going to have any problems in terms of hiding the ball, lying. You're not going to have your credibility challenged. You're going to be honest throughout, and you're not going to send yourself down a rabbit hole because you think you know where the agency's going with the question, and you give something, you give a response that's not responsive to the question, and it can set you up to elaborate for something you don't need to elaborate for. Make them ask you to elaborate. All right. After discovery, Taylor, you can move to the next one, please. After discovery concludes, most likely the judge will have set forth a time frame for the agency to file a motion for summary judgment. Summary judgment is a party who believes that some or all material facts are not in genuine dispute. They may file a motion in support of this contention with the administrative judge. Typically, it's 15 days prior to a hearing, but I should say, most likely the judge's order will say it's 15 days after the close of discovery. Most judges don't set hearing dates until after dispositive motions have been done. So typically the deadline for a motion is 15 days after the close of discovery. But remember, the judge can set dates certain. So it could be 23 days based on what the judge wrote in the order. It is always with what the judge wrote in the order. The opposing party typically has 15 days after the receipt of that motion to file an opposition. In most circumstances, it is the agency who files a motion for summary judgment and the complainant who responds. Because in most circumstances, the complainant is saying, no, there are issues of material fact here in dispute that warrant a hearing, and we must go to a hearing judge. And it's the agency who's saying, there are no issues of material fact here. We don't need to go to a hearing. And judge, you can decide this case on the law, and the law is in favor of the agency. You want to oppose that. There are some circumstances where discovery has been so illustrious that, and you've gotten a lot of really great things, that you can file a motion for summary judgment saying, hey, I have written proof here that the RMO took this action in retaliation, like it says here, right here, because of his EEO complaint. I'm not going to select him. Boom. You can file a motion for summary judgment. That's just very uncommon and not typical, but it doesn't prevent you from doing that. If you have some piece of evidence that big and obvious, you can file a motion for summary judgment, and then the agency has to respond to it. Some judges allow for a reply after an opposition. This will be a very short document, and it's typically filed 7 days after the opposition. Some judges do not allow a reply. So again, you got to look at the judge's order. Some judges set page limits for motions for summary judgment. You must pay attention to the page limits. You can seek to have the page limit extended if you want, but you must file a motion for that. The AJ will consider the motion and the opposition, and then they can either decide to deny the agency's motion, which means you're going forward with a hearing. They may dismiss some of the claims but keep some of the other ones in. So you're only going to have a hearing on some of the cases. They may issue a decision granting summary judgment and not needing to move forward with a hearing, and then they can make other determinations. Bottom line of the judge's decision is, are you moving forward to a hearing, or have all your claims been dismissed? If all your claims have been dismissed, then your case is done before the judge and you have appeal rights. When opposing the agency summary judgment, this is incredibly important. You must look at the agency's statement of facts. They're going to list a statement of facts. You're going to need to go fact by fact and admit, dispute, admit, dispute. If you dispute a fact, you need to say how you dispute the fact, because again, you're trying to show the judge, look how many material facts that the agency identified are material that I actually dispute. And therefore we have to go forward with a hearing. That is a necessary element of an opposition to summary judgment. You must do that. Sometimes a supplemental affidavit for yourself or a witness, a friendly witness, can be included. You can do that. You can submit that evidence with the opposition. All right, next slide, Taylor. Settlement discussions. Settlement discussions, like I've talked about, can happen at any time. Sometimes the agency takes the position that they don't want to discuss settlement until after discovery. So if that's the case, it may be worthwhile to reach back out to the agency after the close of discovery, before they file their motion for summary judgment, and see if they're willing to discuss settlement. There is no requirement that the agency need only to respond. No one is required to settle a case. You are not required to settle a case, a complainant. So no one can force you to settle a case. It is ultimately each party's determination whether they want to settle a case. So a judge cannot order you to settle a case. They can only order you to discuss settlement. And they can order you to make those settlement demands in writing. They can ask an agency to do the same thing, but they cannot force you to settle the case. This is really a good opportunity to have an attorney involved, because it allows it to be very clear. You can have those discussions. And, I think that one of the best reasons to have an attorney is that it takes the emotional element out of it. This is a horrible thing you've been through. It's very difficult, and it's very hard not to have those emotions, very warranted emotions. Having an attorney on your side, you take out that emotional element and you allow those communications to happen without you getting upset, frustrated, and having that impact the settlement discussion. So I think that's a huge value in having an attorney on your side to help guide you through that process. The discovery process is also a very complicated process. It's a lot of work, like I said, and having an attorney to help you guide you through that is, I think, very valuable. So settlement discussions, though, to go back, can happen at any time. It can happen before the initial conference. It can happen during the initial conference. The judge can order a settlement conference and stay deadlines until the settlement conference happens. It can happen during discovery. It can happen after discovery. It can happen after the agency files a motion for summary judgment, although they are more likely to want to wait until the judge makes the determination after they file their motion to have those discussions. But it can happen at any time. And while you may foreclose an offer, you should not foreclose the opportunity to discuss. All right. Taylor, that's again, my contact information is on the screen. You can reach out to discuss more, but I can take questions now if you have them. I know that there have been some that have been going, and I also have some that were submitted prior to the webinar that we can talk about. So some of these I've already gone over, but is filing a motion for summary judgment a normal part of the process? Yes. In almost every single case I have, the agency files a motion for summary judgment. It's kind of pro forma. It is a very rare experience that it doesn't happen. So yes, it's a necessary part of the case. Someone asked, what are the similarities and differences between a discovery request versus a FOIA request? That's a good question. A discovery request is a part of litigation. A FOIA request is a request that anyone can make at any time for information from the government. You might be seeking the same thing in those requests, but if you're in active litigation, you have the opportunity to take discovery. That is the faster way to get information. If anyone's ever submitted a FOIA request, they know it takes a very long time to get a response. Discovery is a lot faster because, again, you have that 60 to 90-day window that the agency has to provide responses, assuming that it could lead to information that could lead to relevant information relating to the case. So you can do a FOIA request at any time, but if you're in discovery, do discovery. Can I request and get a recording of meetings related to the case? I think this is assuming that there was a recording. Let's say there was a standard meeting that was recorded and that that recording exists. Yeah, you can get a copy. Evidence does not just have to be in writing. It can be video evidence. If you have, that there's a camera in the hallway and, it's disputed that this supervisor came over and talked to you and threw a document in your face, and that camera shows it, you can request that. Absolutely. When can a person ask for discovery? Is it before or after conference? In most acknowledgement orders, it says you cannot initiate discovery until after the initial conference. So you must wait for the initial conference. Again, you want to pay attention to the orders, but you have to wait until the initial conference happens and the judge can walk through the claims. What the judge doesn't want to have happen is that there's confusion about what the claims are, and that could result in discovery that is not necessary or tailored to the claims in the case. So they want you to wait until after the initial conference. What is the process for EEO cases assigned to another agency for investigation due to a conflict of interest? This goes back to the formal complaint stage. That's not really a part of discovery. But yeah, if the agency identifies that there's a conflict of interest, they can assign it to another. Some agencies have sharing agreements, so they will do each other's investigations. Some agencies have outside contractors that can do investigations, so they're allowed to do that. Would the agency be involved in discovery requests? Absolutely. Agency attorneys are the ones assigned. They're the representative for the agency, and they will be involved in the discovery. If your case is against an agency attorney, and that attorney notices their appearance to be the attorney on behalf of the agency, you can move to recuse them and have them be a fact witness. But that's a very rare circumstance. That doesn't happen often. Can I schedule back-to-back depositions, i.e. the agency deposed me and then I depose the agency right after? Absolutely. They can happen in the same day. If you think if the agency thinks the deposition, let's say your deposition is only going to be 3 hours, and you think that the RMO's deposition may only be 3 to 4 hours, you could do them in the same day. No problem with that. It's really that process of working out the schedule is something that should be collaborative, not contentious, and should be able to be resolved without any judge interference. How long does it take? Does it usually take from the point of submitting a formal EEO complaint to seeing movement and meeting with a judge? So kind of going over the EEO process, the agency has 180 days from the date of the formal complaint filing. If you amend the complaint, it can be 180 days from the amendment, but no longer than 365 days from the date of the EEO complaint. Like I said, after you file your hearing request, there's no specific timeline. What the specific field office and district office that you're filing in is they're looking at their level of caseload. I've heard that some district offices right now don't have a lot of cases, so it's moving very quickly. And I've heard that other offices have more cases, and so it's moving a little bit slower. It really depends on the office in which you're filing. And you don't have an option. You can't try to pick. It's the office that, typically the office that is correctly identified in the agency's notice of advisement of rights. That's the office that your location is assigned to. So it can depend. Once you do get that initial conference order, typically, like I said, you have the initial conference. Discovery usually lasts between 60 to 90 days. Then the judge sets out that guidance for motions for summary judgment. There is no deadline for a judge to issue a decision on a motion for summary judgment. There's none. I'm sure there's some internal guidance as it shouldn't be any longer than X, but you cannot make a judge move any faster than they want to move. It's based on caseload. It's based on what they have in front of yours, how many decisions they have to do, how many hearings they have currently scheduled. And so you just have to wait. Once you do get a decision, typically the judge schedules a hearing depending on their schedule within 3 to 6 months, something around then. Are there any specific roles or entities excluded from discovery? No. If you're let me make sure I understand the question. You only can get discovery from the agency against whom you filed your EEO complaint. So that is a limitation. You cannot seek to get discovery from another agency. There is a third party, there can be some third party requests. For example, if the agency wanted medical documentation from your doctor, they could try to seek that third party information. But it's typically limited to the agency against whom you filed your EEO complaint. Can you add documents after the final ROI to include medical documents? You can seek to amend, sure, the ROI, but most likely if it's medical documentation, you're not going to have a hard time getting that into evidence at a hearing, but you can seek to amend. It may be granted, it may be denied. How long after appealing a FAD will you get a response? Okay, that's that's outside of the discovery process. A FAD is a final agency decision, and if you want to appeal that, that's usually to the Office of Federal Operations, and there is no set timeline. It's when the Office of Federal Operations issues a decision, so there is no deadline for that. All right. I think I answered that question. I think I have answered all the questions. If you have any more, submit them now so I can get to them. Oh, this is a good question that I saw from the previously submitted questions. Can a deposition be taken by video conference and transcribed by voice to text app? So let me separate those questions. Yes, most depositions actually right now are being done via video conference. Can you transcribe them via voice to text apps? No, you must have a court reporter, and a court reporter must transcribe them in order for it to be a legal copy or a legal transcription of that deposition. Most likely an agency is going to object to trying to use a voice to text app because there's no way to check the accuracy of that, and they're going to want a court reporter. Can the agency depose complainant's doctors? Can they? Yes, it is permissible. Getting a doctor to testify is very difficult. And you have no control over another person. So if the agency wants to depose your doctor, you have an obligation to notice the deposition to the doctor, send it to them, but you cannot control the doctor's participation. You cannot force your doctor to show up. They're their own person. You do have an obligation to send that notice of deposition to the doctor to the best you can. And that's kind of it. But yes, they can. It's permissible. Let me see. If an agency official admits to discrimination in the interrogatories, will they be at hearing, or will this need to be requested? So the I think you're using the word interrogatories as the affidavits that are submitted as the report of investigation. So if the RMO admits to something in their affidavit in the ROI, yeah, I'd want them at hearing. That's great. I want that evidence before a judge. That's great. Now that maybe if it's an outright admission, yeah, I discriminated against that person and I did it because of this protected basis and I would do it again. If it's kind of that admission, you may want to file a motion for summary judgment yourself. But yes, you definitely want that evidence at hearing. 100%. That's great evidence and you should submit it. Remember, in discovery, you're not proving anything, you're seeking information. Just remember that distinction. All right, let me see. Last call for any questions in the chat box. I'm trying to look and see if there's any questions that were previously submitted that I haven't answered. I'm not seeing any others that I haven't answered already. And again, I'm not going to answer questions that are specific to a specific case. So I can't answer anything that would be tantamount to legal advice on your specific case. But if you have those questions, please feel free to reach out and have a consultation. You can ask those questions during consultation and then determine whether you want to move forward with retaining us to represent you. And we can have those conversations then. That's the only way that legal advice can be given. So if you have specific case questions, that's the best way to get those answers. All right, Taylor, do you want to give another second for questions and then we can wrap up?
Yeah, I actually think that we're all set on questions, so we should be good to wrap up if you have any closing thoughts.
So my closing thoughts, I would say, is just discovery is hard, right? You have to relive every single thing that went through. Facing discrimination is traumatic. It's hard. Having someone on your side and your team to help support you through that is worth its weight in gold. There are many, many advantages to having a representative during discovery to kind of take that burden off your shoulders. And so I highly encourage that. That's definitely the time that you want to consider having an attorney on your case. So it is a lot to go through. It is usually in a very short amount of time. 69 days seems long, but it's not. And it's a lot to make sure that you're, meeting all the deadlines, following all the judge's orders. So I would encourage you to reach out, have an attorney with you if you can, and have that support that you need. I want to thank everyone for coming to today's webinar. I hope you have found it useful. And we look forward to seeing you in future webinars and possibly working with you. Everyone have a great afternoon.